WCB 23-147, Dennis Crosen versus Blouin Motors et al. We are being streamed live on the web, both by audio and video these days. I would ask counsel to identify yourselves by saying your name for the record, and I'd ask if you come to the podium to do so because of the cameras. For the appellant.
Good morning, John Cronan for Blouin Motors and the MADA.
Good morning, Kevin Noonan on behalf of the appellee, Dennis Crosen.
Thank you. And counsel, if you're ready, we'd be happy to hear your argument this morning.
Thank you. May it please the court. This appeal boils down to a fundamental issue of the rights and obligations with respect to two dates of injury under the Workers' Compensation Act. As you can see from the briefing, there are two injuries, one in 1984 for which the appellee sustained a date of injury for a prior employer, and one for a 2002 date of injury for which my insured is responsible. My insured, Maine Auto Dealers, the appellants, continued to pay lost time benefits by a decree issued in 2012 until Mr. Crosen began receiving Social Security retirement benefits. The parties reached an informal agreement in 2016, at which time the appellants began taking 60% of the entire offset to which they were entitled. Obviously, in 2021, the 1984 insurer went insolvent, and the Maine Insurance Guarantee Association took over. The appellate division committed a legal error in this case because it relied upon Section 354 of the Workers' Compensation Act, which deals with apportionment decisions, which essentially found that the appellants are not entitled to the full Social Security retirement offset. This provision provides in Section 354 that an employee's benefits may not be reduced on account of an apportionment decision. My clients seek the full Social Security offset to which they're entitled, which is less than the benefit amount they were paying at the time the prior insurer went insolvent. We respectfully submit, as outlined in our briefs, this is entirely consistent with this court's ruling in the Berry case. This is also entirely consistent with Section 2016 of the Workers' Compensation Act, which requires that the court and the board portion out the prior injury rights and obligations with respect to the 1984 date of injury and the rights and obligations with respect to the 2002 date of injury. The decision of the appellate division flips the act on its head, in essence, emphasizing only the appellant's obligations but not the benefits to which they're entitled. And in fact, the entitlement to the Social Security offset under the Urusha case, which this court decided several years ago, is not only a recommendation or something that might happen, it's mandatory under the plain language of Section 221. To the extent the appellee takes issue with the Berry case in terms of whether the court did decide this issue before or didn't in terms of the proration of the offset, we respectfully disagree. The Berry case did not say that there is no entitlement to prorate the offset. But beyond that, the Berry case allowed exactly what we're looking for in this case. The administrative law judge failed to properly apply the law when the judge declined to follow Berry and only allow my clients a portion of the full offset to which they're entitled to under law. I'd open the panel up to questions now at this point.
How does the fact that MATA is now the payer of first resort, if you will, because the guarantee fund is the payer of last resort, how does that change what you are entitled to do as an offset under Section 221? Why is it different because of that than it was before Bedivere went belly up?
Two reasons, Your Honor, and that's an excellent question. The agreement that was entered into by the parties before, which has been referenced by the appellee in its brief, is clearly an informal agreement, which has been referred to the same way by the appellate division. The parties were not judicially bound by this agreement. There was nothing that was approved by the board or submitted to the board in advance. This was an informal agreement that was reached whereby my clients began taking an offset that was less to which they were fully entitled. Since that time, they began paying all of the incapacity benefits, even with contribution from the prior insurer in the form of inflation adjustments that my client has passed along to Mr. Crosen. So the circumstances have changed.
As they must.
As it must. And, Your Honor, I would say as it must is key with Giuliano case on which the appellee relies is respectfully doesn't control this analysis. My clients, the appellant, fully recognize their obligations under the Workers' Compensation Act to pay inflation adjustments to Mr. Crosen based on the prior date of injury, even when the 2002 injury has zero responsibility for inflation adjustments.
And you're not appealing on that issue? I mean, that was an issue before the appellate division, but you're not appealing on that
That's
issue?
correct. My clients, the appellants at this point simply seek the full offset to which they're entitled to under Section 221. As outlined at the time the 1984 insurer went insolvent, the appellants were paying their proportionate share of the benefit payment was greater than the full Social Security retirement offset under Section 221. Again, this is precisely what the appellants are entitled to under the Berry decision.
Can I ask you regarding Section 354, the apportionment section, whether its provision about apportionment decisions made under the subsection may not affect an employee's right and benefits under the Act. Does 354 have any applicability at all at this point because the Rockland Electric's insurer is insolvent? Is apportionment a non-issue anymore?
Your Honor, I would submit that apportionment is still an issue because the Giuliano case says it is. Even when there's an insolvent insurer and MEGA steps in, the apportionment scenario is still in play, although we are as the appellants, are the
Your
only
client's
insurer
picking it up
paying.
as if there is no apportionment, right?
The issue was raised below, the argument was raised below, I should say, that there is no longer any apportionment. But Giuliano does support the proposition that there is apportionment. However, I would add to that response that even with an apportionment scenario here, which the appellants do recognize by virtue of the fact that they are paying the inflation adjustment, I will add, that Section 354 is not affected and the rights of Mr. Crosen are not interfered with under Section 354 by virtue of the relief we request. This is not an apportionment, a request for apportionment relief we're looking for. This is a request for relief to which the appellants are entitled to under the Yerusha case and under
Well, haven't you
Section
contributed to some of the confusion here? Because the Social Security offset is not subject to apportionment, is it? Under 221?
It is not, Your Honor. It's actually, it is a full offset for 50% of the old age Social Security retirement benefits received.
Yet your client agreed to basically give up 40% of the offset, which is mandatory under the statute, is it not?
The offset is mandatory under the statute. I will add that the Yerusha decision that was issued by this court in 2018 postdated the date of the agreement which my clients entered into, with the appellants entered into with appellee. I think that has some significance. Second of all, this informal agreement is the term I will use for this offset, which was 60% of the full offset to which my clients were entitled, was memorialized with a memorandum of payment, which was filed with the Workers' Compensation Board. Has no involvement by an administrative law judge or mediator or otherwise approved by the board.
Are you able to, this is sort of extrajudicial. I'm looking at the 60% agreement that the parties agreed to back in the day. That was never endorsed or was never the subject of a decree, was it?
That's correct, Your Honor.
Simply, was that an agreement? And this is extrajudicial. Was that an agreement between the carriers or was the employee part of that conference? Do you know?
Your Honor, my understanding, to the best of my knowledge.
If you don't know, that's fine.
It's best of my knowledge, and appellee can also weigh in, is this was an informal agreement between the carriers at the time, based on the apportionment in the decree. But again, I don't have 100% crystal clear knowledge on that. That is to the best of my knowledge. But
And
again, it was not endorsed by an administrative law judge.
And you agree that with respect to the 1984 injury, that predated the Social Security offset provision, so there was no offset that's due with respect to that 1984 injury?
Absolutely, Your Honor. We have no dispute that the 1984 date of injury has no provision for a Social Security offset. It carries with it the obligation to provide for inflation adjustments, which my clients are doing, which was found applicable by the board. However, the 2002 date of injury does have a Social Security offset requirement.
But to be clear, you're only, even if we agreed with you that you could offset the full amount of the Social Security payment on account of the 2002 injury, you're not seeking to get a credit further back than 2021, are you?
No, at this point, we're seeking a credit for 2021 to the present, under the Yerusha case, based
Yes.
on the insolvency. Thank you.
Okay, thank
Is
you.
there a mechanism for you to recover under 221, with the coordination of benefit provision? Is there any mechanism for you to actually recoup the amounts that your client voluntarily seemed to forego, or in terms of not taking the full
That's
offset?
a very good question, Your Honor. There is a provision under the Yerusha case. There's obviously an entitlement decision issued by this court in Yerusha. There is an entitlement by the insurer to recoup sums paid under the Workers' Comp Act while an employee also receives Social Security retirement. I think your question goes to how that would be implemented, and that would be something before the Workers' Compensation Board, typically done based on the facts and circumstances of the case. And
Well, the Arusha case utilized Section 354, I believe, with respect to the, 324, excuse me, with respect to the recovery of payments in a circumstance in which either benefits have been approved, they've been paid, but it turns out that they weren't owed, and then in that circumstance, if there is a delay as a result of motion for further findings of fact or as a result of an appeal until you get to the result that declines the benefits, then there's an opportunity to recoup, correct?
there's an opportunity to recoup in that situation, Your Honor. I believe you're talking about when there's a decree in place and there's a lump sum of benefits awarded. At that time, the parties say, here's what's due to the employee and here's what's been paid. That's one scenario when this could be how this would operate. The other scenario is when benefits are being paid either voluntarily or by decree ongoing and an employee begins to receive Social Security retirement unknowing to the insurer and those benefits are paid. So it can be done in the scenario where there's a lump sum payment retroactive, and it can be done in the other situation. But the Arusha decision obviously is a clear mandate about the application of Section 2.
So I think we've gone a little bit around the barn on what I think one of my original questions was, and I think I understand your answer now, which is, my question is whether the insolvency in 2021 actually impacts your entitlement or not, or how much the credit or offset you get under Section 221.
Yes, that is an excellent question because the insolvency triggered the filing of these petitions.
I understand it, which, as a practical matter, it triggered the filing. It meant that suddenly your matter was paying a lot more money.
Correct.
But my question is, as a matter of statutory interpretation, does that actually have anything to do with entitlement to the Social Security offset?
As a matter of statutory interpretation, it doesn't. In fact, as a matter of statutory interpretation, there would be arguably entitlement back to the date Mr. Crosen began receiving Social Security benefits in 2016. Again, this is a right under the Act to which the appellants are entitled. And this is an informal agreement that was never approved judicially and has no binding effect before the Workers' Compensation Board, in our view.
Is there any negative consequence to you if your client decided to forego recouping the amounts back to 2021 that were overpaid?
Your Honor, I'm not sure if there's any negative consequence. I know it's very advantageous as an employer and insurer in a system that's geared towards cost containment and cost control to seek those kinds of recoveries, and that's, I guess, is a hypothetical.
Ballpark, we're talking about $3,000 or $3,600 or somewhere in that ballpark?
We're talking about a sum that going back to 2021, that's correct, yes. But this is a situation where, in this case, we are taking affirmative steps to recover it. As we've outlined in our brief, we're looking for a recovery under Arusha for not only an ongoing full offset, but a prior offset. at
Thank
that
you,
level as
counsel.
well. Thank you, Your
You'll
Honor.
have an opportunity for a rebuttal. And Mr. Noonan.
May it please the court, as I indicated, I'm Kevin Noonan, and I represent the appellee, Mr. Crosen. It's important to keep in mind when you're deciding this case that the 1984 neck injury that is involved here, under the law at that time, there were no offsets for Social Security retirement. Those offsets were passed by the legislature and went into effect June 30th, 1985, and they were not retroactive. The current offset provision is Section 221. That came into effect in January of 1993. And again, it was not retroactive. In fact, the specific statutory language of the massive overhaul of the Workers' Compensation Act that went into effect January 1st of 1993, Section A10 specifically said, so as not to alter benefits for injuries before January 1993, certain provisions will not apply to those injuries, including Section 221. Section 221 has never applied to any injury before 1993. Really, this is nothing more than an apportionment dispute. That's what the Giuliano case told us. This is apportionment still. The case law on apportionment has consistently held that these are disputes between insurers, and the injured worker is to be made whole. The statute, Section 354, we've talked about that this morning, specifically says apportionment decisions may not affect an employee's rights and benefits. And Section 2016 of of the Workers' Compensation Act specifically says, if an employee suffers a work-related injury that combines with the effects of an injury that took place prior to 1993, the employee's rights and benefits for that portion of the resulting disability that is attributable to the prior injury must be determined in the law in effect at the time of that prior injury. The law in 1994 did not allow Social Security offsets. That has never changed. And that portion of Mr. Crosen's claim that applies to the 1984 injury cannot be affected by statute. Now, the appellant basically is saying we ignore the apportionment issue. We're entitled to an offset on our own for the 2002 injury under Section 221. And that's basically the Berry issue. Now, keep in mind, the primary issue in Berry had nothing to do with proportional offsets. In fact, the court specifically said, we're not dealing with proration or proportion. The primary issue in Berry had to do with Mr. Berry had retired and was collecting Social Security retirement benefits and then went back to work and got hurt. And the question was whether the Social Security offset applies in that circumstance. And the court said it did, and that was ultimately changed by the legislature. They said, no, that's not fair. If someone's receiving retirement benefits and then gets hurt, we're not going to allow an offset under those circumstances. That's the primary issue.
Mr. Noonan, I see that the green light is on. Can I return and make sure I understand the facts here? The amount that the Automobile Dealers Association is paying on account of the 2002 injury exceeds 50% the Social Security offset. In other words, 50% of the old age benefit that your client receives. Is that correct?
Yes, I believe the figures are that the appellant, MADA, was paying $235 a week, and the offset, a full 100% offset would be $233 a week.
And so does Section 3543 even come into play unless they were trying to reduce the amount on account of the 1984 injury? In other words, if they take the full offset on account of the 2002 injury, that's not affecting the amount your client would be receiving on account of the 1984 injury. And it doesn't change the apportionment, does it?
Well, I think if you're going to do that, which is what the appellant is arguing, you basically are looking at Section 221 in a vacuum. And I don't think you can do that. You got to read Section 221 in conjunction with 354 in 2016. 2016 specifically says that the portion of disability attributable to the 1984 injury must be determined by the law in effect at the time of that injury. Portion is another version of proportionate. The legislature's...
But that's why, isn't that why, let's say that the numbers were the inverse and that the 2002 injury was only 30 or 20% of the total amount, right? And the 1984 injury was the majority. Then they wouldn't allow, under the sections that you're citing, whether it's 221, whether it's 354, et cetera, you couldn't exceed the amount that the employer was liable for on account of the 2002 injury for the Social Security offset. It couldn't eat into, essentially, the benefit to which the employee is entitled for the 1984 injury, right? But couldn't they still get their entire, essentially, have it offset the entire amount if they were only liable, say, for 20%?
Well, I'm not sure I'm completely following, but here's my problem with this sort of analysis. I have to explain to Mr. Crosen, okay, Mr. Crosen, you have a 1984 injury that's 40% of your disability, and yet you're going to get 100% Social Security offset as if the 1984 injury didn't exist. They're going to get 100% as if you had just had a 2002 injury. You're going to lose $233 a week in your compensation benefits. He'll say, well, what happened to my 1984?
Explain it better than that.
What's that?
I said, you could explain it better than that.
Well, I don't know.
Well, it's a legal matter to the extent that with regard to the 1984 injury, there was no offset that's applicable. And it was a voluntary agreement that I believe in 2016, after the apportionment was made, it was a voluntary agreement by which they didn't take, MADA didn't take the full offset at that point, correct?
Well, I think, I mean, neither Mr. Cronan and I were directly involved. We obviously have the files and reviewed them. There was active discussions between all the parties about what was to happen, and the agreement was made to take a 60% offset because I think they realized that was a fair proportion based upon section
Well, was
2016.
Well, it may have been fair. Was it legal?
Was it legal? Absolutely it was legal.
To the extent that the statute requires that the full Social Security offset be taken with respect to any injury after 1993, that was not consistent with the law, was it? The agreement to not take 40% of it?
Well, I think you're looking simply at section 221 and ignoring 2016, which says you have to proportion of disability attributable to the 1984 injury must be determined by the law in effect at that time. You have to read both statutes together.
Right, but why can't they offset 50% of the Social Security benefits up to the amount they're responsible for on account of the 2002 injury, but certainly not on account of the 1984 injury?
Because you're giving them the entire Social Security offset as if the 1984 injury ceased to exist or didn't exist. Basically, they were only entitled to $233. Even if he had only had a 2002 injury and he was never hurt in 1984, they would only get $233 per week offset. So you're basically ignoring the fact that a portion of his claim is the 1984 injury, and 201 says you have to portion of disability attributed to that injury cannot be affected. That's what 201 says, and you're ignoring that. You're giving them the full offset as if 1984 didn't exist, and ignoring the fact that we can talk about whether this was informal or not informal. They agreed to it, and they had paid this offset in that
But
fashion.
does that bind them? We can talk about whether it might bind them prior to filing the petition in this case in 2021, but do you think that that binds them going forward?
Well, they also signed a stipulation of facts saying that's what they were doing.
I understand that's what they were doing. There's no question about that. Do you think that that binds them going forward?
Well,
I mean,
I think
obviously, the whole purpose of this is their position is it doesn't bind them going forward.
Well, and their suggestion is that the bankruptcy has something to do with their ability to, bankruptcy has nothing to do with this. The bankruptcy.
That was apparent that I asked that question, what was the relationship, but you haven't answered my question, which is, are you suggesting that their voluntary agreement to take only 60% of it binds them going forward?
I think the stipulation of facts binds them. I don't think the voluntary memorandum.
But they didn't stipulate that they were going to continue that. They stipulated that they did it in the past.
This is true. I agree with you on that point, but I think that binds them. And as a practical matter, I think it's beyond the pale to make the agreement, pay under it, and then say, oh, by the way, we want our money back. I don't think the bankruptcy changed anything here. The statute and case law have consistently held that an injured worker's rights and benefits are established at the time of the injury, and bankruptcy doesn't change that. The appellant is trying to use the bankruptcy as a distraction, a ruse to distract us from the fact that they made the agreement to pay a proportionate share and paid for 8 years before this became an issue under that agreement. They shouldn't be allowed to get out of their agreement now. And they're also respectfully wrong about the review criteria.
Well, I'm not sure I understood your last answer to the Chief Justice. You say they want their money back. Let's separate for a moment what happens prospectively versus what might happen with respect to the retrospective piece. My question to you is, do you think that they are, for some reason, now bound from actually deducting the full Social Security offset moving forward prospectively?
Well, I think the stipulation of facts binds them, but putting that aside, I think the law binds them under 2016. It says they have to respect that proportion that's paid under the 1984 injury. I think 201 it would be inconsistent giving them 100% of their offset when the statute specifically says they're only supposed to pay that portion. 201 says portion of disability attributable to the 84 injury must be determined by the law in effect at the time. That's why they
Why
reached
the offset can't eat into what's due on account of the 1984 injury,
I'm sorry.
which is why the offset cannot eat into what would be payable on account of the 1984 injury.
But it's also why they should not get 100% of their offset, which is what you would be giving them if you say, well, because their compensation is more than the offset, they get 100%. I don't think that's appropriate and fair. It is inconsistent with 2016, which says you're supposed to use proportion. And they
But they
agreed
would
to-
still be receiving the full benefit with respect to the 1984 injury, would they not? If the offset's only taken against the payments coming as a result of the 2002 injury.
But he's losing more on the 2002 injury than he should be entitled to lose, because there are two injuries here. You're giving him the full offset as if he only had one injury. There are two injuries, and one of them, the offset doesn't apply.
Right, and there would be no impact on that injury, the payment for that injury.
Well, he's losing about $100 a week under that.
Let's just do the math.
I
If the
understand.
entire offset can be recouped with respect to the payments that are coming as arising as a result of the 2002 injury, am I mistaken from a mathematical standpoint that there's no impact on the benefits being paid with respect to the 1984 injury?
But I think we're going around and around a little bit, Your Honor, but you're giving him 100% of the offset, even though it's only 60% of the claim. That's and ignoring the section 2016 that says it's supposed to be a proportion. But yes, you can mathematically take all but $2 of the 2002 injury claim based upon 100% of the Social Security offset. I just don't think that's what the statute requires. Yes, that is true.
Without using the actual numbers, would you step us through the mathematical process? Where do you start? Where do you apply? What do you do, in your view?
I think you do exactly what was done when this gentleman started collecting his Social Security retirement in 2014. You take, okay, there's an offset of $233. We're only 60% of this claim, so we don't get 100% of that. We get 60% of that, and that was, I think, $140, and we'll take that offset. That was the agreement, and there was a reason. They're not in the business of giving away money. There was a reason they did it that way, because it was fair and consistent with Section 201.
So your math is you take the total amount of the offset to be entitled to and reduce it by 40%. Is that the bottom line?
Yes.
Pitching to us? Okay.
They pay in proportion to their what they're obligated to. That's what 2-1 says, pay in proportion, portion. Respect to the appellant, I also want to point out that, the position is that once a petition for appellate review is granted, that we can't look at the review guidelines. I don't think that's consistent with the rules, appellate rules. I think the rules specifically state.
So are you asking that the appeal be dismissed as improvident, or the petition be dismissed as improvidently granted?
And here's why. I don't think this is an issue that's likely to occur. You have to have an injury that occurred before June 30, 1985. There aren't many of those around anymore. There's certainly not many around where there's a bankrupt insurer. So this is a very rare and unusual issue. And there's no substantial error of law. We think that the decisions of the administrative law judge and the appellate division are consistent with the statute, and most importantly, there's no substantial prejudice to the appellant. How can there be substantial prejudice to the appellant when they agreed to this in the first place? They agreed to it, and they paid this way for 8 years without any dispute. There can't be substantial prejudice when they agreed to it. So it's our position, yes, that this does not meet the review criteria and should be dismissed, but obviously, respectfully, if you disagree, we think that the decision of the administrative law judge and the appellate division should be affirmed. Thank you.
Thank you. Cronan, you reserve some time for rebuttal.
Yes, thank you. Briefly, in response to the appellee's arguments regarding the Rule 23 criteria, with respect to the likelihood of this issue recurring, with respect to the issue of prejudice, the key issue here is a significant error of law, which we submit has occurred based on the appellate division's decision. In terms of this informal agreement, I would submit to this court that the stipulation that was entered into by the parties was clearly and was, I will say, in lieu of a testimonial hearing, as the Chief Justice indicated and is correct. This was a stipulation to demonstrate to the board what had happened and what the parties agreed to, not what the parties were going to agree to prospectively. Second, also as the Chief Justice said, the Section 221 cannot eat into the prior benefits being paid on the 1984 date of injury. That is the test under the Berry decision, and that is the test that the court ought to apply when it reviews the appellate division's decision. So I would submit to the court that the appellate division committed a very significant error of law, and that the decision ought to be reversed consistent with Berry, that Mr. Crosen's benefit entitlement under the 1984 date of injury will not be affected under Section 2016 or Section 354 when the mandatory offset under Section 221, which this court has indicated is required, under the Urusha decision is applied to this case. So,
Attorney Noonan is suggesting that the court should view the benefit as a single entity, although it derives from two separate injuries, and therefore that the offset has to be applied to the total benefit. I think the implication is he's suggesting that only a percentage of the total payment should be applied because the 1984 injury is not subject to an offset. So how do you respond to that?
Your Honor, I would say to that, I understand Attorney Noonan's view about the totality of the offset, but basically in this case here, we're dealing with a situation where the disability is in fact represented by the amount of benefits attributable to that disability and that injury, which in this case is an amount that Mr. Crosen continues to receive. So I view it as that way, respectfully, as the appellants, that this is the piece of the pie to which Mr. Crosen is entitled to under that injury, and it's not affected by this offset for which we seek, and again, for which is required under the Workers' Compensation Act.
What about the argument that this is unlikely to come up ever again, so why are we looking at it?
You know, Your Honor, to that argument, that's an excellent point. I would say the most significant issue here is the significant issue of law. I do disagree with the appellee that this is an issue that will never happen again. This injury was 38 years old. You know, these are injuries that are prior to 1992. We're dealing with lack of Social Security offset. There are still many workers' compensation injuries out there with pre-1992 and post-1992 dates of injury. In addition, there are also many situations, unfortunately, where insurers are insolvent as well. So I think that this is likely to recur in the future, in addition to being a significant error. Thank you.
Thank you for your arguments in this matter. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. It's also my understanding, Mr. Cronan, that this is your first time arguing in front of the courts.
Actually, 2012, it's been a long time, but I was here a long time ago.
Oh, well then, this is wrong. I was told that it's been,
No breathing for him.
then never mind, you don't get to come back.
Proportionately.
Is it proportionate? All right, well, then with that, we'll be in recess on this matter.
All rise.